Hi, welcome to Trustee School. I'm excited to have you spend some time with me today to learn more about what it means to be a trustee or a successor trustee to your trust. During this time, I encourage you to take out a piece of paper and a pen and go ahead and jot down any questions that come to mind as we go through this. And please feel free to reach out to me by email, or you can call and schedule a time to chat on the phone for about 15 minutes if you've got questions that I can answer after following this presentation. So let's get started. I'm just going to tell you a little bit about myself. I'm not going to spend a lot of time on this, but just to say again, my name's Laura Bromlow. I have been practicing in the area of estate planning and estate administration since 2012. That followed up a time period in my life where I was a stay-at-home mom for about 6 or 7 years. And when I came back to the legal field, I decided I wanted to give myself to helping families. And so the reason I spend my time in this practice area is because I get the honor to come alongside families and help them communicate, which allows them to avoid broken relationships and allows them to avoid family drama. So my highest purpose is to serve God's children, and the way I found best to do that is to serve the families that come into my office. So that's a little bit about me. I want to give you an overview about what we're covering today. The scope of the discussion today really has to do with trustees of revocable living trusts. There are a lot of other kinds of trusts out there. There's irrevocable trusts, there's ILITs, there's special needs trusts, a lot of other kind of specialized trust. We're not speaking to those specifically. So it's important to know, because those kinds of specialized trusts will have additional responsibilities, will have more specialized responsibilities. And so you need to keep that in mind. The presentation today will still apply to those people that are trustees of those kinds of trusts. For example, there's going to be fiduciary obligations that are going to apply to all trustees, and we will be talking about that. So just wanted to put that out there. So who's going to benefit from today? Well, if you have created a revocable living trust with myself or any other estate planning attorney, you're going to benefit from this presentation. If you've been named as a trustee or a successor trustee, you will benefit. If you're a beneficiary of a trust, you're going to learn some things that you have a right to know, and how trustees should be doing things. And then finally, I just want to say that this is really intended for the non-professional trustee or successor trustee. So we're not really talking about corporate trustees as much in here, although they do still have fiduciary obligations and that kind of thing. But mostly I'm speaking to non-professional trustees. So here's what we're going to cover today. We're going to review what a revocable living trust is, and what are the obligations of a trustee. We're going to talk about the role of a trustee during incapacity of the grantor or settlor. We're going to talk about the role of the trustee after the death of a grantor or settlor. And we're going to talk about any ongoing trustee roles. And so what is a trust? So we're going to start with that question. A trust is a three-party contract. So you've heard of contracts. You enter into them every day, buyer seller contracts. And usually they're two parties. Well, this one happens to have three parties. And what we're really doing here is we're taking ownership of property and we're putting three different hats on it. And so it can be divided up. Your ownership of property can be divided up three different ways. First of all is the trustor, also called the grantor or settlor. The trustor is the person who creates the trust. So that would be my client. Those are the people that come into my office and say, we need to do an estate plan in case we become incapacitated or die. We want to make things easy on our kids. And so they're the creators of the trust. They get to say who plays what role. They get to say what assets go into the trust. They get to decide everything about this trust. They're the creators. The second party to the contract is the trustee. The trustee is the person who manages what's inside the trust. So they're the person who would be able to sell the house that's owned by the trust, or be able to take out another mortgage against the house that's owned by the trust. They're the people that would say, hey, I don't like the way this financial advisor is investing this money for me any longer, or the trust any longer, so I'm moving it to another financial advisor. Or hey, there's some money in this investment account that's owned by the trust. The trustee could take that money out and purchase a vacation home if they wanted, for the benefit of the third party, which is the beneficiary. The beneficiary is the party who gets to receive all of the benefit of the trust assets. So I kind of picture them as like a baby being fed. So they're the ones that just get fed, the beneficiary. So in my case, when couples come in to see me, let's imagine Bob and Sue come in to see me. They're going to be the creators of the trust, the grantor, settlor, they're creating it, but they're also going to name themselves as the trustee, as the people who can continue to manage all those assets that they already own and the assets that they're going to end up not owning, but putting into the trust to own. And they're also going to name themselves as the beneficiaries for as long as they live. So as long as they're alive, they're going to be the beneficiaries. As long as they're well and able, they're going to continue as the trustees. So nothing really changes for Bob and Sue. They will continue to be acting in all three roles, wearing all three hats. But it's just that they're not going to be on title as the owners. The trust will now be on title as the owner of their assets. The revocable living trust that we're talking about does not change how they report their taxes. It doesn't even change how their taxes are calculated. They're going to still have the same amount of tax liability or not. So it doesn't change any of that. It also does not change their liability. So it doesn't give them any liability protection or anything like that. That's a common misnomer, that if you put something in a revocable living trust that you're going to get protection. That's not true. There's other kinds of trust that might give you that, but not a revocable living trust. The whole purpose of the revocable living trust is to avoid court when you become incapacitated and to avoid court when you die. So the whole purpose is, we call it a probate avoidance vehicle. So we're going to think about, as we talk, we're going to think about a timeline, right? Right now, we're talking about while Bob and Sue are both alive and well, what is happening to the trust and the trust assets. So first of all, while they're alive and well, they've created this trust that they're going to be in all three roles of. They're going to put all of their assets in the trust. What this means is they go into the bank and they take it out of their name and put it in the name of the trust with themselves as trustee. They have me prepare a deed of their house. Now it's not going to be owned by them. It's going to be owned by their trust. So it's just retitling assets into the name of the trust. They're going to put all their real estate, all their cash assets, and all their personal property into this trust. There are a few things that will not go into this trust because they're not allowed to by law, or because it just doesn't make sense. And those things are going to be retirement accounts, qualified retirement accounts, as well as life insurance policies. Those are going to continue to be owned by Bob and Sue, or the clients. And instead of having the trust avoid probate court at incapacity and upon passing, we are now going to have a power of attorney in place at the institutions where these retirement accounts and life insurance policies are held. So a power of attorney appointing an agent to have access to these assets upon incapacity. And then we're also going to do a beneficiary designation so that when the settlors or clients die, that it pours into the trust. So that's the beneficiary designation, is going to name the trust as the beneficiary of that asset. So that is how we will handle that. Now, when Bob and Sue are managing their trust, they don't have to, because they're alive, they're well, they don't have to worry about any of the successor trustee duties. But let's talk about what happens first of all, let's step back and talk about what a trustee is. So a trustee is a fiduciary under the law, as is an agent under the power of attorney, and as is an executor in a will document. So these are all different documents that name different parties as a fiduciary. And a fiduciary has a legal obligation to do things for the benefit of either the beneficiary in a trust document or for the benefit of the principal in a power of attorney document, okay? So the trustee as a fiduciary has these obligations. A trustee may not make a profit off of the trust. So they're entitled to reasonable compensation, yes, to reimbursement for maybe legal fees or other fees to take care of the trust. But they're not entitled to make a profit off of the trust, right? That would conflict with their duty of loyalty, which you'll see down at number 6. A trustee owes beneficiaries a duty of full disclosure of all material facts known to the trustee that affect the beneficiary's rights. And so full disclosure to the beneficiaries. Trustee has a duty to keep accurate trust records also so the beneficiary can see what's going on with the trust. A trustee owns a fiduciary duty to preserve and protect the assets of the trust estate. So we don't want a house just sitting there vacant with no electricity, no plumbing. That kind of thing is not going to be protecting an asset if that house is owned by a trust. You have to protect and preserve it. A trustee owes a fiduciary duty to administer the trust in accordance with its terms. So yes, you have to follow the settlor's wishes that are outlined in the trust document. And then finally, a trustee owes a fiduciary duty of fidelity that forbids the trustee from placing himself in a situation where there is or could be a conflict between the trustee's self-interest and the trustee's duties to the beneficiaries. So they cannot be benefiting. They have to put the beneficiary's needs ahead of themselves when it comes to the trust document. Now, we're going to talk about the trustee's role during incapacity of the trustee. So this is on that timeline where both trustees, in the case of Bob and Sue, are still alive, but neither of them has capacity. We think they're losing their mind, maybe they're getting dementia, whatever it is. They're both alive, but they're not well, and they're not able to manage their own trust. So now successor trustee steps in, and they're wondering, what do I do at this point? Maybe it's mom and dad, maybe it's aunt and uncle, maybe it's grandma and grandpa. What do I do when these settlors become incapacitated? Well, first of all, you must establish incapacity. If you're a client of mine, you will find in Article 4, we outline a definition of incapacity. Most trust documents will define what incapacity means so that we know when a successor trustee can take over. Not only that, but it will define incapacity and also say who gets to decide if you meet that definition. And so oftentimes in trust documents, that's going to be 2 doctors providing written notice that yes, indeed, you meet this definition of incapacity that's spelled out in the trust document. Sometimes it's not going to be 2 doctors. It's going to be what I call a disability panel. Some combination of people, maybe it's family members, maybe family members plus a specific doctor or family members plus any doctor, something like that. Either by unanimous decision or by majority decision, that you meet the definition of incapacity and that the settlor meets the definition of incapacity. So either way, you look to the trust document. In my case, it would be Article 4 of my trust documents, where we spell out not only the definition, but how do we determine that you meet the definition? And you got to follow that first, successor trustees. So you establish capacity. You're probably going to need help from an estate planning attorney at this point, just to make some simple documents for you to help you establish incapacity. Then you'll also gather all the estate planning documents. And if it is an emergency situation, such as a rush to the hospital or something like that, you're definitely going to need the estate planning documents, specifically the medical documents you're going to want to have right on hand. You're going to want to implement the instructions within the revocable living trust. So again, in my documents that will be found in Article 4, how do I administer the trust during the settlor's incapacity? Oh, we'll look to Article 4 in my documents. In other trust documents, you're going to find a section that talks about how to administer trust assets, revocable living trust assets during the settlor's incapacity. And you're going to need to follow that section. But typically this will be, you're going to, manage and secure assets, and you're going to pay bills on behalf of the settlor. So you're going to maybe pay their healthcare bills, their house bills. Maybe they need long-term care or a caregiver in the home somehow. You're going to be paying those kinds of things. And then the trustee will also handle tax returns. And so you're going to make sure that while settlors are incapacitated, you're helping them file by filing the income tax returns. Okay, but what I want to mention here is don't be afraid to ask for help. So you do have professionals in your corner, and you may and likely will need them. For one, you'll need an estate planning attorney to prepare some simple documents. The attorney's involvement can be simple or complex depending on the situation. CPA may need to get involved with the tax situation, and then a financial advisor is always so helpful for a successor trustee as well, to make sure you're investing the assets prudently. Okay. And then now we're going to talk about the trustee's role at the death of the grantor. So here we're moving along in our timeline. If we have a spousal situation, we've got one spouse who's deceased and one who is alive but incapacitated. So again, if the situation is that one of the settlors has died and the surviving settlor appears to be incapacitated but has not been declared incapacitated yet, because maybe the one that passed away was doing the work and, handling the trusteeship for the surviving spouse, and now it becomes apparent that the surviving spouse is incapacitated, then we're going to go back to those previous steps about proving incapacity and making sure that we're going through all the steps of establishing incapacity of the surviving spouse. At any rate, there's some additional things that will happen now that one spouse is deceased. You will have to make, no, you won't necessarily have to make, but you may need to make some tax elections. This will be decided in working with a CPA and with an estate planning attorney. And so as the successor trustee, you reach out to a CPA, you reach out to an estate planning attorney, you all get together, you talk, and you say, does this estate for the deceased spouse, you've still got a surviving spouse, does the estate of the deceased spouse warrant the surviving spouse making any tax elections? So some examples might be portability, disclaimer, but these are all terms of art that belong in the tax field, and the answers all revolve around tax consequences. So you need to look at the tax laws at the time. And you as a successor trustee don't need to know these tax laws, but you do need to be able to go out and get professionals that can help you with what is the current tax law. Do I need to make any of these tax elections? Okay. You're going to handle the assets. So you're going to collect, make valuations of maybe real estate or businesses, things like that. You're going to manage and invest. So you're going to make all of those decisions. Now, what you're really doing is sort of an administrative time is going on here, and you're gathering assets, you're figuring out what's there. And so in my practice, what I do for clients during the estate planning process is I create a spreadsheet. So I would recommend that if you are not already in the successor trustee role, but you are going to be stepping into that role at some time in the future, that you get with your settlor and you say, hey, do you have a spreadsheet yet? Do you have all of the assets written down so that's easy for me to find when I step into this role? The idea is that my clients get a binder with all of their estate planning documents. They also get a folder, an envelope with all of their original documents in it. And they also get a flash drive with a digital copy of all of their executed documents on it, so that the successor trustee can find it. And in that binder, the spreadsheet that I've created with all of their assets, all the trust assets, is in there, so that the successor trustee can flip to it. They can see, oh, this is where I need to go. These are all the assets I need to take care of and quantify. So what the successor trustee is doing is they're saying, okay, which of these assets were deceased spouse's separate property, which are surviving spouse's separate property, and which are community property, in which case we divide them in half, and half goes to the deceased spouse's share and half goes to the surviving spouse's share. We need to have that all on paper and know what we're doing before we take any further steps. Then you pay the taxes and expenses of the deceased spouse, and then you're going to continue to pay bills for the surviving spouse. But here's what it's going to look like. So you've got this revocable living trust. You've gathered all the assets. You've decided these are the deceased spouse's assets. These are the surviving spouse's assets. And somebody's died. And so we're going to send all of the survivor's assets over here to the survivor's trust. So this survivor's trust is just like the revocable living trust, where it belongs really for tax purposes and liability purposes. It belongs to the surviving spouse, and that's going to include all of the surviving spouse's separate property and their share of community property. And that's going to be a revocable trust that the surviving spouse could amend or revoke at any time. And it's all includable in the survivor's estate. Okay. Then we need to look at, what about the deceased spouse's property? What are we going to do with the deceased spouse's property? Well, one option that could be in the trust, and you have to look to the trust to see what they chose, what they decided, is that it goes all over into the survivor's trust. If it is all going to the survivor's trust, then it goes over there. You don't create any new, you don't get any new tax identification number. It is still filed under the surviving spouse's social security number. It causes no new tax returns. You're going to continue to do the things that you were doing, while they were alive, just paying for the survivor. Now everything is for the benefit of the surviving spouse, but there's nothing new on your administrative part that you need to do. If the trust has the deceased spouse's share going to the marital trust and or a bypass trust, then there's some additional things that need to be considered. So if it has it going to one of these or both of these trusts, the reason is for tax reasons that they did this, or for protection purposes. So there's specific protections that they can get with these kinds of trusts that they can't get if it goes over to the survivor's trust. So just know, if it is going into these are irrevocable trusts. The bypass and marital trusts are irrevocable trusts, and they need their own tax identification numbers, and you will need to do separate accountings for each of them every year. So you will have to keep up with that. And then you're going to make sure that you make distributions from these trusts based on what the trust document says. So the trust document may say the bypass trust is to be distributed for the surviving spouse's health, education, maintenance, and support. It may say the bypass trust does not go to the surviving spouse. It goes to the children. Or it could say the bypass trust goes to the surviving spouse until they get married. If they get remarried, then it goes to the kids. Okay. So you have to read the trust. The marital trust is always going to be available for the surviving spouse. So the income and principal of a marital trust has to be available for the health, education, maintenance, and support of the surviving trust, but maybe it was created for some protection reasons. So that's how you need to be on the lookout in your trust document for whether the deceased spouse's share is all going to the survivor's trust, or whether it's going to a marital trust or a bypass trust or some combination. And you will often need help interpreting that with an estate planning attorney, because the language can be kind of complicated and you'll need help understanding. So again, seek help on that. The trustee's role in here where we're talking one spouse is still alive, one is deceased. So again, each trust is going to have its own rules for distribution, the bypass, the marital, and the survivor's trust, right? Usually even the marital and the bypass trust usually are for the benefit of the surviving spouse, but sometimes they're not. So you got to read that carefully, read all the governing parts of the trust document to make sure you're doing it correctly. And don't forget to do your accountings and tax filings on these irrevocable trusts. Okay, and moving on in the timeline, now both settlors pass away. When both settlors pass away and the successor trustee steps in, now we have slightly different roles. First, we're going to do that administrative part again. And again, for my single people who only had a trust that was created by a single person, this is just upon the death of the single person. In that previous discussion about the bypass and marital trust, they don't really apply, but now we're back to this applying to single people as well. So when the settlor is deceased, the trustee is again going to collect the assets. What is there in the estate? Make sure they have a good understanding of that. They're going to maybe do some valuations. So maybe they've got real estate that needs a valuation done on it for sales purposes, for distribution purposes. We need to have that done clearly. And then we're going to pay the debts and expenses of the final spouse to die, and we're going to make distributions either outright or into trust. And so here I'm going to talk a little bit more about these distributions and the trustee's role. So really this time period after the final settlor has passed, the trustee's role can be pretty quick. It can go pretty quick. Depending on the complications of the estate, right? So if there's tax complications, it can make it draw out longer. If there's a lot of debt owed, it can draw out longer. If there's a lot of different gifts made within the trust, it can make it last longer, because you've got to make sure you've got enough assets in the trust to handle all the different gifts and all the different debts and all that stuff. You don't want to start making distributions until you know you've got enough for everybody in the percentages that are mandated. So once you've made the distributions, though, your role as successor trustee of that original trust is done. But it may continue if your distribution that you're making is to another trust. For example, if I have a distribution in my trust going to my 2 children and they are minors, my trust will likely say that I want the distribution to go into a common trust until my son, the youngest, reaches the age of 22 or 23, or until he's graduated from college. If my trust has that distribution going into a common trust, and I haven't elected anybody else as the trustee of that trust, successor trustee, it's going to likely be you that's going to be the trustee of that common trust until my son reaches the age of 22 or 23. So now you're managing a new trust. So you've done that administrative trust, and now you're moving on to the role of trustee of this common trust. And so you need to look at the terms of that trust, which is also going to be described in this document. And the terms of that trust, maybe for the health and education, maintenance and support of both of my children, but not necessarily equally. Okay. And so you would continue that. Then when my son reaches the age of 22 or 23, maybe I have it, the terms of the trust say, okay, then whatever is left in the common trust, which is everything, should be split equally into 2 shares, one for my daughter, one for my son. But they should go into lifetime trusts for their benefit. And these lifetime trusts get their own tax identification number, just like the common trust did. So now you've got more work to do. And maybe the trust document allows them to be their own trustee, or maybe you need to stay on as the trustee of their trust until they reach a certain age. Okay, so carefully read the document. And if you are the ongoing trustee, your obligation is going to be to administer, make distributions according to the terms, whether it's for the health, education, maintenance, and support. It might be absolute discretion. So you might be able to distribute for any reason whatsoever or not distribute. Your distribution standard might be it's only for education. It could be many things. Or there's distribution standards that give it out at a certain age. So a certain amount at each age, that can also be the distribution standard. So you have to look at that. At any rate, it's getting its own tax identification number. It's requiring its own accounting. So you will have ongoing obligations to manage that the way it says, and to make sure you're managing it probably with a financial advisor so that you're doing it prudently and that you're doing the accountings appropriately. Okay. Now, beneficiaries do have rights. And so what you need to know as a trustee is that beneficiaries have the right to be notified that you're taking over as trustee, and that they have a right to be informed about the trust. And so you'll have to give them annual accountings, and that you're making timely distributions, so that you're making distributions in accordance with the trust provisions and that they are made timely. Okay. Great. And so what I want you to know is when the final settlor has passed away, what do you do? What's your initial to-do action? And your first action is to be a family member. There's a reason that your loved one set this trust up. They wanted to make things as easy as possible on you, the successor trustees, on their family, on their loved ones. They wanted everybody to be able to come together and support each other, not tear each other apart. So take time to breathe and grieve and just be a family member. So that is the most important thing. You will need to locate the estate planning documents, and then reach out to an estate planning attorney. Maybe within a month or 2 should be sufficient. Do that. Just make sure that you're aware of what actions. The estate planning attorney will help you come up with your next actions. And then before you go into that meeting, though, make sure you have a list of all the assets, or as much as you can, a list of all the assets. Hopefully your loved one was very good at organization, or they were my client and they had a spreadsheet. A note right here to all my clients who are watching, or who are any people out there who are doing their estate planning: make sure that you update this list of assets that you have, whether in trust or not. And make sure you update it on a yearly basis. So I tell my clients to think about, at tax time, pulling out that sheet and saying, are all of these assets still trust assets, which aren't, and make sure you make a note of it. Are all my assets listed here? If I'm missing one, add it. If one no longer belongs to me, let's get rid of it. Let's take it off of the sheet. So keep that updated yearly. And I like to tell my clients to think about it around tax time. Very important for your successor trustee. Now, finally, there are some things that trustees should not do. And so I know that I probably don't have to tell most of you this, but I'm just going to share them in case you didn't think about it. Don't use assets for your personal use. Don't be using, money out of the trust account to pay for your mortgage or, for dinner or anything like that. Don't use it for personal use. Don't act alone if you're appointed as a co-trustee. So maybe your parents couldn't decide which kid to choose as the trustee, and so they appointed you both as trustees. Make sure that you're having regular meetings to discuss. If one of you wants to continue as a sole trustee, talk to the estate planning attorney about it. There might be a way for one of you to resign as trustee and the other one to continue on without a co-trustee. So just make sure you're communicating with your estate planning attorney if that's the case. But don't act alone if you're named as a co-trustee. Make sure you're acting in conjunction with your co-trustee. Don't commingle your trust money with your personal money. Okay, so you've got to keep a separate account for trust money and a separate account for your own personal. Don't not respond to beneficiaries when they have questions or requests of you. If you don't know how to answer a question or a request from a beneficiary, then go ahead and talk to your estate planning attorney about it, but don't just ignore it, because the main reason your loved one did these documents is to avoid conflict in the family. And so we don't want to stir up drama. Okay. So that's all I have to say about the don'ts. I know, again, most of you won't do those, but I like to mention them just in case you hadn't thought about it. Again, don't be afraid to ask for help, right? We're here for you. You need an estate planning attorney, you need a CPA and a financial advisor, more likely than not. If you need help finding a CPA or a financial advisor, we can help you find those people. But they are your go-to for help throughout this process. So I just want to say, we're here for you. I want you to reach out to me. If you've got any questions, hopefully you've jotted down a few questions during this presentation. And if you have, and you would like answers to those, please don't hesitate to reach out and get in touch with us. Here's my address, here's my phone number, and my email address. If you would like to make a telephone call appointment, I'll do 15-minute calls for you to answer your questions. It's best to reach out to my assistant, Dina, which is just dina@bromlowlaw.com. So it's like that email with info, but instead of info, just put Dina, D-I-N-A, D-I-N-A. And she can schedule, a 15-minute phone call with me, and I can answer your questions that way. Or you can just email info@bromlowlaw.com, ask your question, and I'll get back to you as quickly as I can if you want it by email. So, anyway, I hope that this stirred up some questions for you, made you think. I hope you learned a lot, and I hope you got some good advice on how to prepare things for your successor trustee as well. Happy to have you here. Thank you so much for attending. Bye now.